everyone. Today we are going to discuss about the topic contract and business law. First of all, what is meant by contract? A contract is an exchange of promises. That means one party is offering something to other party. Here, both are exchanging their promises between themselves. If the other party accepts the offer, then it becomes an agreement. When such agreement fulfills the conditions of Section 10 of Indian Contract Act, it becomes the contract. So here, Section 2H defines a contract as an agreement enforceable by law. What is meant by enforceable by law? Means possible to make people obey or possible to make happen or be accepted. So, contract is equal to agreement plus enforceability by law. Before we enter into the topic contract, we must know about agreement. Agreement means a mutual understanding between two or more legally competent individuals or entities about their rights and duties regarding their past or future performances and consideration. An agreement is defined as every promise and every set of promises forming consideration for each other. Section 2 under Section E means a promise is defined as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, it becomes a promise. Section 2 under Section B. In other words, an agreement is an accepted proposal. To form an agreement, there must be a proposal or offer by one party and its acceptance by the other. To sum up, agreement is equal to offer plus acceptance. The next thing is all agreements are not contracts, but all contracts are agreements. Under Section 2H of Indian Contract Act 1872, an agreement enforceable by law is a contract. So, the most important character is that an agreement must possess in order to be a contract is its enforceability in law. For example, X, a person, invites another person Y for dinner. Here, Y accepts but fails to turn up for dinner. Here, X cannot go to the court to claim his loss. So, if we have the intention to create a contract, we have to make it eligible to be enforceable by law under Section 10 of Indian Contract Act 1872. Therefore, every contract is an agreement, but every agreement is not a contract. Let me explain the definition of a contract. According to Salman, defines a contract is an agreement creating and defining obligations between the parties. Obligations means duty or commitment. So here, to create a mutual understanding between the two or more persons to do their duties or commitments. The next thing is, according to Pollack, every agreement and promise enforceable by law is a contract. Here, the most important thing is contract should not be against the law or against public policy. Example, a contract to commit a crime would not be legally enforceable. So here, contract is equal to agreement plus enforceability by law. Next, we are going to see the essential things of contract. The essential things needed to make a valid contract is, first thing is offer and acceptance. What is meant by offer and acceptance? Offer means it is voluntary but conditional promise submitted by a buyer or seller, that is offerer to another offeree for acceptance, and which becomes legally enforceable if accepted by the offeree. An offer is a clear indication of the offerer's willingness to enter into an agreement under specified terms and is made in a manner that a reasonable person would understand its acceptance will result in a binding contract. So, there must be a lawful offer and a lawful acceptance of the offer, thus resulting in an agreement. The second essential thing is intention to create legal relations. There must be an intention among the parties that the agreement should be attached by legal consequences and create legal obligations. Example, agreements between husband and wife also lack the intention to create legal relationship and thus do not result in contracts. The third essential thing is lawful consideration. An agreement is legally enforceable only when each of the parties to it gives something and gets something. The something given or obtained is the price of promise is called consideration. Consideration has been defined as the price paid by one party for the promise of the other. For example, A agrees to sell his books to B for ₹100. B's promise to pay ₹100 is the consideration for A's promise to sell his books and A's promise to sell the books is the consideration for B's promise to pay ₹100. The next essential thing is capacity of parties. The parties of an agreement must be competent to contract, that is eligible to the contract. Otherwise, it cannot be enforced by court of law. The persons are not competent to contract is a minor, a person of unsound mind, a person disqualified from contracting by any law to which he is subject. The fifth essential thing is free consent. Free consent of all the parties to an agreement is another essential element of a valid contract. Free consent means parties must have agreed upon the same thing in the same sense. Under section 13. There is absence of free consent if the agreement induced by coercion, undue influence, fraud, misrepresentation, mistake. If the agreement is vitiated by any of these factors, the contract would be voidable. Voidable means that is nullity and cannot be enforced by the party guilty of coercion, undue influence, etc. The other party can either reject the contract or accept it subject to the rules in the Act. If the agreement is induced by mutual mistake, which is maintained to the agreement, it would be void. Section 20. The sixth essential thing of contract is lawful object. The parties to an agreement must agree for a lawful object. The object for which the agreement has been entered into must not be fraudulent or illegal or immoral or opposed to public policy or must not imply injury to the person or property of another. If the object is unlawful for one or other of the reasons, the agreement is void. Example, landlord lets a house to a prostitute to carry on prostitution. He cannot recover the rent through a court of law. The seventh essential thing of contract is writing and registration. According to Indian Contract Act, a contract may be oral or writing, but in certain special cases, it lays down that the agreement to be valid must be in writing or and registered. Example, it requires that an agreement to pay a time-barred debt must be in writing and an agreement to make a gift for natural love and affection must be in writing and registered. Section 25. Number 1. An arbitration agreement must be in writing as per the Arbitration and Conciliation Act 1996. Number 2. An agreement for a sale of immovable property must be writing and registered under Section Transfer of Property Act 1882 before they can be legally enforced. The eighth essential thing is certainty. In order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. It must be possible to ascertain the meaning of agreement, for otherwise it cannot be enforced. The ninth essential of contract is possibility of performance or doctrine of prestation. Here, an agreement to do an act impossible in itself is void. If the act is impossible in itself, physically or legally, the agreement cannot be enforced at law. The doctrine of frustration applies when, after a contract has been entered into, some supervening event occurs that makes performance of the contract radically different from what the parties had contemplated when they entered into the contract. The last essential thing is agreement not declared void or lawful agreement. The agreement must not be one which the law declares to be either illegal or void. A void agreement is one which is without any legal effects. Illegal agreement is an agreement expressly or impliedly prohibited by law. Example, agreement in restraint of trade, marriage, legal proceedings, etc. are void agreements. Those agreements prohibited by the Indian Penal Code. Example, threat to commit murder or publishing defamatory statements are agreements which are opposed to public policy are illegal in nature.